Search and seizures in school. Student rights. Debbie Reed. The Fourth Amendment in the Constitution allows people to secure their persons, houses, papers, and effects against unreasonable searches and seizures. Courts give schools and police more leeway in conducting searches in schools. Schools must balance the rights to privacy for students with the safety and discipline. They must have probable cause, which is a reason to suspect that a person has committed a crime or a place is connected to a crime. They need more than just suspicion, but less than legal proof. They must also have reasonable suspicion, which is a careful presumption based on specific facts and circumstances that a person has been involved with a crime. There are several different types of searches that can be completed. We're going to start with property searches. Schools' responsibility is the safety of students, provide the best education, free of disruption. This allows for flexibility in conducting searches at school, their grounds, and parking lots. Information leading to searches can come from students, school employees, and police. Locker searches. Lockers are property of the school, so it is permissible to search student lockers. Lockers can be searched if there is concern by officials that lead to finding evidence of a crime or a violation of a school rule. Many schools have policies in place pertaining to locker searches. Backpacks. Schools have the ability to search backpacks or purses if there is a reasonable suspicion of a law or school rule being broken. Cars. Cars parked on school property or school parking lots are subject to searches. Police dogs may come in to sniff cars in school parking lots. When a police dog hits on a car, that gives officials the ability to begin a search. Searching a student. One must have suspicion of an individual student before a search can be performed. Strip searches are unconstitutional except for extreme cases, such cases of weapons or drugs involved. Unless other students or personnel are in imminent danger, strip searches should be left to law enforcement officials. If a strip search is performed, there should be a witness of the same sex of the student present. Searching general population. Drug-sniffing dogs are permissible as ruled by the U.S. Supreme Court. It is not a, quote, search, unquote, under the Fourth Amendment. School officials do not need individualized suspicion in order to perform a drug search. Our school has random dog searches for both cars and lockers. We had one incident where a dog hit on one of our teachers' desks. The police officer asked the teacher to unlock the desk, and when it was opened up, they found tennis balls. The dog hit on the tennis balls because that's what they use for a reward for making a hit. So the dog just got a little bit excited thinking it was time to play. Drug testing. In 1995, the Supreme Court ruled that drug testing can be performed without suspicion. Urine samples are not what is considered an intrusive search. Schools may require students in extracurricular activities to have a drug testing as ruled by the Constitution as well. Metal detectors. Schools having general safety concern at their school may use metal detectors. Schools must be concerned that the students are bringing weapons to school. All students must be subject to the metal detectors with no discrimination. School search and seizures, fight not over. A Springfield, Missouri school may be going to U.S. Supreme Court before long. At issue, can schools be locked down to allow in drug-sniffing dogs? This started with an incident in 2010 at Central High School. 2 students allegedly had their possessions rummaged through. It alleges this is a violation of their Fourth Amendment rights. The current rulings with this case, the U.S. District Court of Western District of Missouri ruled that it was not a violation, and this was reaffirmed by the Court of Appeals. Judge Diana Murphy ruled that there was not a violation of school policy or students' privacy rights. Students were asked to leave the room before the dogs did the searches. I found this article interesting because it did mention that Kansas considered taking part in the litigation, but they felt the case was unwinnable due to the local court's conservative nature. Some closing thoughts. School officials, law officials must continue to keep the safety and welfare of the students first and foremost. They must be diligent in making sure they understand the rules. They must find a balance of respect and privacy when it comes to students' rights. And we must make sure that all individuals working in our school systems are well educated when it comes to school law, especially with search and seizure. Thank you.